Well, it's the end of the year and perhaps time for a little bit of reflection. Maybe there's an episode earlier in the year that you missed, but fear not. Today we're going to go through every single CRPA lawsuit that is currently active. You might just be surprised by how much CRPA litigation is out there. Let's talk about it. Hey everybody, welcome back to the channel today. That's right, it is the end of the year, and what better time to review everything that we've done throughout the course of 2024. Wanted to go over litigation and just see all the different lawsuits that CRPA has been involved in and what the progression has been like for this year. Obviously, some of these lawsuits span prior to 2024, but we want to really focus on what the lawsuits are about and the progression for this video that we've seen this year. To do that, we've brought back the president of CRPA, that is Michel. Chuck, thanks for being with us today.
Always a pleasure, guys. Thanks for having me. Very excited to talk about all the stuff we've been doing.
Yeah, absolutely. And guys, before we get into it today, please be sure to like, share, and subscribe to these videos. We're trying to get this information out there as far as we can so that everybody can be informed. We are seeing a shift in the culture in California and the country. There really is no better time than right now, especially in the current California regime, to be a Second Amendment advocate. We're trying to bring as many people as we can into the cause, and you can directly contribute to that by liking, sharing, and subscribing. So please go ahead and hit those buttons for us. So Chuck, I guess before we jump into the individual lawsuits, just an overall assessment of the year 2024. How did it go as far as Second Amendment litigation is concerned?
Well, let me go back a little further. You know, CRPA has been involved in litigation for your right to keep and bear arms for 30 years now. Before the Heller decision in 2008, we really didn't have the Second Amendment hammer to use in these lawsuits. We were using arguments like due process and equal protection and preemption, and we made some headway with those. But as the legislature turned to almost a supermajority and then a supermajority, so that the Democratic platform and the machine could pretty much control the agenda, they passed a lot of new laws in like the early to mid 2000s. After Heller came down in 2008, they kept trying, and finally Bruen came down in 2020, or was it 2022, and changed the game on Second Amendment and set up a new methodology, a new test for determining whether or not a gun control law was constitutional. CRPA is continuing to litigate throughout California, but now it's also a national game. You've got Illinois doing semi-auto bans, Oregon, Maryland, a number of other states doing semi-autos or magazine bans or limiting where your CCW is valid. And behind all this is the Bloomberg Group and Everytown Law. They are spoon-feeding these battleground states model gun control laws. And frankly, I think some of their strategies to try and overwhelm us so that we can't keep up with all their new laws. And they're getting more and more creative in the kind of laws they pass, more and more specific and sort of obscure in some senses. But so CRPA is working with groups across the country now, including to a big way, the Second Amendment Law Center, which is coordinating friend of the court amicus brief campaigns in these cases. But it's important for CRPA to be involved either as a friend of the court amicus or an advisor or a consultant or whatever in all these cases, because when you win a case in one circuit, federal circuit, it's persuasive authority in other federal circuits. And obviously, when you win something in the Supreme Court, that's mandatory authority all across the country. And so the game has been to get, after Bruen came down, the anti-gun lobby played the same games they had played after Heller, which was to try and distort the ruling in Bruen so that they could continue to uphold gun laws that clearly violate the Second Amendment. And so it's been a game of fighting back. And CRPA is deeply, deeply involved, primarily in California, but also across the country, in fighting back against their efforts to restrict your Second Amendment rights.
Yeah, I think that's kind of a fair point to start out with. You know, we talk a lot about lawsuits that are happening in the Ninth Circuit or the state of California, but we also, over the span of this year, have talked about some lawsuits that don't necessarily reside in either of those arenas. And the question that's becoming more and more common is, how is this going to affect us here in California? And it seems like those answers get more and more drastic. So the identification that it is a national game, and to maybe go somewhere else to positively affect us here in California might be necessary in the overall grand scheme of things. And I mean, now that you say that, it almost seems prudent. We'll have to have you back to talk about some of the lawsuits that are happening outside the state of California and how they're affecting us. Yeah, we can do that one here. But while we're here, I did want to discuss some of these lawsuits, and I say some, but you guys, it's kind of a lot of lawsuits. So, Chuck, let's kind of start with some of the more recent ones. We've got a lawsuit titled Jaymes v. Maduros. As far as the challenge is concerned, the primary talking point out there is this 11% tax that's been instituted for firearms retailers. They've got to submit their reports to the Department of Justice and pay this 11% tax. Obviously, the way these things work is that it ends up trickling down to the consumer overall. Can you give us the history of this lawsuit briefly and what we saw in 2024?
Sure. Well, remember, one thing that's weird about tax laws is that there are special restrictions and procedures on what you have to do to go about challenging them. And the most obvious one of those is that you have to pay it first. You can't just proactively challenge a tax law. You have to pay the tax and then sue to get it back. And the defendant is a different entity. Usually we're suing the California Department of Justice as a law enforcement agency. In this case, we're suing the state tax board as a tax collection agency, saying you can't collect these taxes anymore. So as soon as this law passed, we filed a lawsuit to challenge it, but we couldn't really add a lot of the retailers and some of the end buyers to the lawsuit until they had paid the tax. So that took a while. Also, this challenge has to be in state court instead of federal court. So there's a Second Amendment component to this, but it is primarily a tax law challenge. And essentially what this tax does, it's charged gun owners for firearms being misused by criminals. It's like charging someone who takes a prescription medication for Colombian drug cartels flooding the country with fentanyl. The gun owners didn't cause the problem, and they're not the ones who should be paying to solve it. This is a general societal problem that should be coming out of the law enforcement general fund to fight gun crime, as opposed to gun ownership, which is not a crime and is protected. So, but this is all part of the gun ban lobby's strategy, which includes a lot of politicians and bureaucrats in Sacramento, to make it as expensive and difficult and cumbersome, logistically difficult to buy a gun. So you've got to jump through a lot of hoops, cut through a lot of red tape, and in their view, and they want to make it harder to find a place to buy a gun, and they want to make the process as complicated as possible, and then they want to make it as expensive as possible. And that's what this did. But there's been challenges in Illinois. Illinois was kind of the leader in trying to impose taxes, and we've had some successes there that we're using as precedent in this case. But at this point, we've added the FFLs, added some retailers to the lawsuit to challenge it because they have paid the tax now. But it's plodding along in state court, and we've just got to keep pushing it.
So, I mean, you could probably assume that as far as like the things that we report here on this channel, it's probably going to ramp up in 2025. This year was about filing, getting our ducks in a row, making sure that we had the proper challenge to the proper place. So looking forward to seeing what we can get out of that one. I know that it's kind of tough sometimes to look forward to returning to the normal. But that essentially is what this is. We're seeking to eliminate this newly imposed 11% tax on the retailers, which the consumers then feel. How about the CRPA versus City of LA? There's a lot of questions, and I mean, it seems like we got an answer as far as the court is concerned, what's the progress and history of the CRPA versus the City of LA lawsuit?
This is actually CRPA versus the County of Los Angeles and the Los Angeles County Sheriff, because the LA County Sheriff is not devoting the manpower necessary in the CCW application processing unit to move these to get these applications processed fast enough. So this case initially, and for now still is, a challenge to those unreasonable delays, and also a challenge to the costs that some cities were charging, like Laverne was charging $1,000 to get your permit. Now, the permit's only good for 2 years, so the state is effectively charging you $500 a year to have a CCW permit. Well, that's not the way constitutional rights work. So we've challenged the delay, we challenged the cost, and we also challenged, interestingly enough, non-resident preclusion. In other words, if you're not a resident of California, you weren't allowed to apply. And we got an injunction, and now the sheriff's people from outside California can apply. And the sheriffs have to set up a process to accept out-of-state applications, and that's being put into place right now. And that's going to, I think, wind up changing the entire process at a state legislative level, the entire process for applying for and having an application for a CCW processed, because they have to set it up. They're probably going to we're going to urge that they make the licensing period longer, like 5 years, like it is in most states, and do some other things to simplify things and get the costs down. So, but we're waiting for the judge to sign this order on setting up the out-of-state applications, and then we're moving through discovery, and there'll be either another injunction or a motion for summary judgment to compel the LA County Sheriff to process applications faster. Sometimes they were taking up to 18 months, and the judge recognized that that's just too long.
Yeah, and I guess a little bit of backstory on this one, if I remember, you can correct me if I'm wrong, but it's like the Bruin decision comes down, and some sheriffs who weren't necessarily operating this way, those departments see the Bruin decision and they start operating in a way that is conducive with the Bruin decision. Some of them still don't. Some of those were in the Bay Area. One was LA County. So then CRPA then goes and sends demand letters to these sheriffs saying, hey, you got to comply with Bruin. And then even more started complying with Bruin after that, but LA County just can't seem to get it. And I don't know if you end up wanting to call this political activism or a shortage of resources or whatever, but it ends up that we have to file a lawsuit. And this is one this year that we actually saw some good consequences, real world application of consequences from a lawsuit. The injunction that we got ended up legalizing out-of-state CCWs for to come in the state of California, where we weren't allowing them prior. So looking forward to continuing. And it's another lesson that we learned earlier this year. There is a difference between an opinion coming down and an order being signed. So a judge can make a decision, they can write the opinion, and we know what's going to happen. But like we saw in the gun show case, until that order is actually signed, it's not necessarily applied to law enforcement. So there's another lesson there. Let's move on to another one that was kind of crazy.
Hold the thought just a second before we move on from that one. I will let people know that this was a product of the CRPA CCW Reckoning Project. After Bruin came down, CRPA sent letters to pretty much every issuing authority saying, here's what you have to do now. And a lot of them, basically it was educational, but also if you don't do it, we're going to sue you. And it told them you have to set up a system, you have to accept applications, you can't charge too much, you have to have objective criteria for issuing a CCW, and you have to issue them. And so a lot of cities that were not necessarily vehemently inclined politically one way or the other changed their practices and actually started issuing CCWs, even San Francisco. But remember, before Bruin came down, most of the red counties they were effectively shall issue even then. And that's because of the Peruta case, which we did years ago, which became a very persuasive authority. And a lot of the more conservative sheriffs recognized that they really shouldn't be stingy with these permits. They should be giving them out on basically a shall issue basis and not abusing the good cause standard to use that as an excuse to not issue permits. So it's a process, and LA County Sheriff became the place where it all kind of landed to focus when, after all these other issuing authorities shook out and started changing their game and issuing permits.
Yeah, and I think if I didn't mention that earlier, I should have. There were plenty of counties in California that were very willing to grant CCWs. So it's the ones who continued to refuse to comply with Bruin who end up getting those sort of notices. Let's move on to another one, though, that was kind of crazy, especially at the beginning of the year, and that's May v. Bonta. This one has to do with the Senate Bill 2 being passed, enforcing sensitive places in California. If you remember, we kind of went through a crazy week at Christmas and New Year's time because the federal district court gave us the injunction we wanted, and then this is when we learned about the difference between a motions panel and a merits panel, because the motions panel then stayed the injunction, only for the merits panel to reinstitute the injunction. But the case has come a long way since then. Can you give us a little bit of a 2024 breakdown for May versus Bonta?
Yeah, well, remember, this is like a Newsom brainchild to try and make your CCW worthless. For 125 years, since CCWs have been available in California, your CCW enabled you to take it just about anywhere, as long as you had your CCW and it was carried properly. You could take it to what the state then, just recently in Senate Bill 2, tried to retroactively declare to be sensitive places, which effectively turns them into gun-free zones, even if you have a concealed carry permit. So we challenged that immediately, and it wound up going up to the Ninth Circuit, where we had sort of a split decision. We got some of these sensitive places declared to be not sensitive. Others still were held sensitive. So your CCW is still good in most of those places, and there's more information about how to comply on CRPA's website and also my law firm's website. So you can still take your gun if you have a CCW, but you may have to unload it and put it in a locked container, which is a typical way to transport one, as opposed to carrying it concealed in a holster and loaded, as a CCW historically has allowed you to do. And anyway, that the three-judge panel in the Ninth Circuit split on some being sensitive legitimately and some being unconstitutionally declared sensitive, so they're not. And so we've asked the en banc panel, the 11-judge panel of Ninth Circuit judges, to hear that case and straighten out the ruling, so that all these cases are declared are declared to not be sensitive, where guns can be banned.
Yeah, and this one, Hawaii didn't exactly get the luxury that California got in this decision, but one that was gonna, we were kind of talking about being extremely detrimental in the state was what the vampire rule is. And so the vampire rule was not put into effect. That was the part of the law that would have forced businesses to put up a sign that says firearms are welcome here, as opposed to it being a responsibility of the business to put up a sign that says firearms are not welcome here. Big distinction there. So as a CCW holder, if there's no sign like that, you don't necessarily, have to worry about going into a business.
That was a big win, because effectively, the vampire rule says that in folklore, a vampire can't come into your house unless he's invited. Well, right. This was, you can't bring your gun in unless I post a sign that says you're allowed to. Well, nobody's going to post that sign.
Right.
Why would they go through the trouble? So now, if they want to exclude guns, you post a sign that says no guns allowed, which is how it works in every other state. And remember, that's private property. You can't force, you have no Second Amendment right to take a gun into your neighbor's house or a gun store, or not a gun store, but a retail store, if they don't want you to, because they control that lease. They control that property. It's not government property. So they can say no guns, but the state wanted to set it up so they had to say guns okay, and then nobody would say it. And so they would effectively ban guns, CCWs, in all those retail private locations.
Yeah, and that one is still going to be litigated at the Ninth Circuit. We'll see what the en banc panel decides to do. Let's move on to another one. This one is a little bit tougher. We try to do as much promotion for this one as possible, simply because there's a component of FFLs being in compliance with the law. This is Richards v. Newsom, where they implemented a standard for security cameras that, quite frankly, aren't even owned by the FFLs. They're owned by the Department of Justice, having to be installed in an FFL to do a certain standard of recording for the state. Can you tell us a little bit about this challenge and the progression in 2024?
Well, we filed for an injunction and we lost because the court said, despite the fact that, remember, sometimes there are FFLs conducting business in their private homes, and this requires you to have a camera that's on all the time, which is effectively looking inside somebody's private home. So the court denied our request, and we're now on appeal to get this privacy invasion struck down. And this is more than just Second Amendment. Again, this is also a right to privacy issue. The state is essentially, this is 1984, man. This is surveillance cameras watching what's going on inside of a gun store all the time. And we're hopeful that the Ninth Circuit will knock it out. And remember, all of these things eventually could make their way to the Supreme Court. And this is what's going to happen. You have CCW issues, you have semi-auto bans, you have magazine bans, you have school-free zones or gun-free zones. And all of those things, as time goes by, the issues will become more and more refined. And so the Supreme Court's going to take a case which hopefully sets the methodology straight in everything. It doesn't matter what the topic is, the gun control topic is. It just matters if they're following the Bruin methodology correctly. So any case that the Supreme Court takes could set that straight and resolve a lot of these lower court cases where there's differences of opinion from the courts.
Yeah, and this one in particular, it's kind of disturbing when you have a requirement for not just video but also audio in perhaps a home FFL. I mean, really what it requires is to have audio and video wherever transactions are made or wherever firearms are stored. If you're a home FFL and the safe that you have is in a spare bedroom and you want to have family over, you're now recording video and audio in a bedroom where somebody is sleeping. That's a huge constitutional violation. So there are definitely problems that we see are worth fixing with that one, and hopefully the Ninth Circuit can square it away. How about Boland v. Bonta, Chuck? I mean, we saw some big splashes with this one in 2023 when we got the federal district court decision essentially removing the microstamping requirement from the Unsafe Handgun Act, which allowed us to bring new firearms that currently weren't on the list able to come in. What was the progression that we saw on this one in 2024?
Okay, so we got a great win on from the district court on this. Knocked out the roster, basically. Said you couldn't require a loaded chamber indicator or a magazine disconnect or microstamping. The state appealed, and interestingly enough, they did not appeal their loss on the microstamping argument. Instead, they repealed the microstamping law. They're going to try and replace it in 2028. But in a different form. But for now, microstamping is not a requirement for a gun to be listed on the roster in California. Now, we want to knock out the roster entirely because all that does is make it impossible for people to get the gun that's most appropriate for their individual circumstances. There's only, I can't remember the exact number, but it's like 1,000 guns on the roster, and many of those are just color variations, finish variations. As opposed to another state where there's tens of thousands of different models of firearms available to buy, and you can choose one that works right for you and your circumstances and the size of your hand and the intended use of the firearm. All those things you can't get you can't get the latest and safest firearms in California because the newer models, if they didn't have a loaded chamber indicator or a magazine disconnect, couldn't be sold. Now, the court has, for now, stayed the ruling with respect to the magazine disconnect and the loaded chamber indicator. So those are still required, but microstamping is not. So several new guns have come on the market that don't have microstamping because they don't have to, but do have the loaded chamber indicator or the magazine disconnect. And now we're fighting with DOJ about what they're requiring from manufacturers to satisfy their definition of a loaded chamber indicator, like a weep hole versus some kind of signage, or the warning on the side of the gun, the letters aren't big enough or bright enough or yellow or red or whatever. They're just trying to make it difficult to satisfy even the requirements that remain. But we had oral argument in the Ninth Circuit on this in August of this year, August 2023. So it was a while ago. But this case has now been stayed because of we're waiting for the Duncan ruling to come out of the en banc panel in the Ninth Circuit. And Duncan was the magazine capacity case that we won twice in front of Judge Benitez.
Yeah, that's right. Actually, now I am remembering. They just came out and flat out said it that they're going to stay this until they hear a ruling on the Duncan case. They were, I guess, as a panel, pretty upfront about that. So, not too many opportunities for reporting on this throughout the year, simply because we're waiting for Duncan. This one honestly is kind of a weird one for me. I don't really understand it. You have, as time goes along, the invisible hand of economics, kind of dictates progression with things like this. As new technology comes out, firearms actually become safer. They become more ergonomically correct. They become easier to use or more specific towards certain uses. And I just always kind of found it interesting that we have these self-proclaimed progressives up in Sacramento who are literally creating these laws to block progression, especially when it comes to safety. So hopefully once the Duncan decision has come down, we can see some progression in the Boland case at the Ninth Circuit and get a good decision to wipe this Unsafe Handgun Act away so that we can actually get safer and newer firearms into the state. That ultimately is the goal. What about the Junior Sport Magazine versus Bonta case, Chuck? This one was kind of another one of those where it was going back and forth. I think we got a bad decision from the from the federal district court, and then this was the one where the Ninth Circuit basically remanded it back, saying you need to apply Bruin. Can you give us the brief history on this challenge and the progression we saw throughout the year?
Well, let me take a second and jump to Duncan, because we need to understand what's going on in that, because the rest of these cases are all someone bottlenecked up behind Duncan. So Duncan is the case that we filed years ago challenging the magazine capacity limitation law. And that was the little self-promotional thing of wasn't governor then, Gavin Newsom. To become governor, he ran Prop 63, which set up an ammo background check, ban on interstate sales of ammo, and set up ban on possession of magazine, even those that had been grandfathered in from before. So we challenged that immediately. We won in front of Judge Benitez down in San Diego. It went up to the Ninth Circuit. We won in front of a 3-judge panel. So the 3-judge panel agreed with us that the magazine capacity limitation law was unconstitutional. That then went en banc to an 11-judge panel. We lost in en banc by 2 votes. And so we appealed to the United States Supreme Court. This was all before Bruin had come down. The U.S. Supreme Court held the Duncan decision until after they ruled on Bruin. Then they said they vacated the en banc loss, sent the case back down, said reconsider everything in light of what we said in Bruin. The en banc panel then sent it back down to Judge Benitez, where we litigated the case again in the trial court and won again. And it went back up to the Ninth Circuit, and then the en banc panel took it back. Rather than going through a 3-judge panel, the en banc panel had to jump straight up to them. Now, that's fairly unusual. And a lot of the judges on the Ninth Circuit took exception to that and actually criticized their colleagues publicly for playing those games. And that was covered in an article in the CRPA magazine about how they maneuvered that last month. But so that case is fully argued in front of the en banc panel, and we're waiting for a decision. But it's been I can't remember exactly when the ruling came down, but it was almost a year ago now. So they've been sitting, the en banc panel has been sitting on their Duncan ruling for quite some time. And in the meantime, other cases, because it's going to decide the methodology again, uh, the other cases are also going to have to apply the Ninth Circuit methodology, whatever it winds up being. And so a lot of those have been stayed. So while we're on this, so the Rupp v. Bonta is CRPA's so-called assault weapon ban challenge. That's in the Ninth Circuit on hold pending Duncan's ruling. And then we've got Rhode, Kim Rhode, the clay sporting clay shooter that we all, an Olympic gold medal winner that we all know and love. She's the lead plaintiff. That case had oral argument just last month, and it seemed to go well, at least with two of the judges, but we'll have to see.
I was just going to say, basically what you have here is you have the linchpin in Duncan, which has been a challenge since 2016 when Prop 63 came in. Part of Prop 63 was the ban on magazines that can hold more than 10 rounds. Because that one's kind of been in the queue the longest, it's gone the furthest. You have other lawsuits like the Boland decision and Rhode that are basically saying we're not going to give our opinion until we see a decision on Duncan. Rhode really has the same path and the same story as Duncan, just a different part of the challenge. Rhode is to the ammunition regulations, right? This is where we're challenging the interstate commerce with getting ammo across state lines, as well as the background checks that we have to go through, whether it's the $1 or the $19. It really shouldn't be either. And the state is looking to up those the fees for those in the incoming legislation as well. They've already put that out there, but essentially you have the Duncan decision as kind of the leading witness for all of these other lawsuits to kind of domino over once that opinion comes out.
Now, Rhode doesn't necessarily have to be boxed up behind Duncan because it's not a hardware case. It's a procedural case, running these background checks, and 10 to 15% of the background checks are wrong. They say somebody's prohibited when they're not, which just points out how screwed up California's database of criminal convictions and gun owners. The government cannot keep a clean, accurate database. They're not. It's just beyond their capabilities. So lots of people get declined. They can't buy ammo, even though they should be able to. And so that's the problem with that. That's why the district court, again, Judge Benitez, found that this ammo background check law was unconstitutional as well. Okay, so I didn't mean to mess us up here. So let's jump back to Junior Sports Magazine v. Bonta. This was the attempt to prohibit advertising firearms or shooting sports or anything that might appeal to minors. Never mind that junior shooting sports is a big thing. And that's why they have a Junior Shooting Sports Magazine, which was the named plaintiff in this case, because this is a First Amendment violation as well as a Second Amendment violation. And now we're getting, unfortunately, sometimes you get wrapped around these procedural axles. We try not to do something, get in a fight over standing or some legal precedent that doesn't really get you to the prize, which is declaring a particular gun control unconstitutional. But the state loves to get you wrapped up in these side arguments. And one of the arguments they have here is that when we won in the Ninth Circuit and it struck down this law, the DOJ then said, well, they didn't really struck down that whole law. They only struck down one portion of it. So now we're back up in the Ninth Circuit again, back in front of the same panel that we had a good result with before, saying, look at the game they're playing here. They're trying to say that your decision only covered this one subsection and that they can still do all this other stuff to ban minors from learning about firearms. And so we're fully briefed on that. And I think we're going to get a decision fairly soon from that same three-judge panel that we won on last time.
Well, and this was a particularly devious one. I mean, you're talking about the implementation of a $25,000 fine for every instance of breaking this law. Excuse me. And I guess when when you're trying to interpret something like this, if I've got 3 kids and I'm going to the range and you're going to interpret a flag that says Glock on it as breaking the law, is that 25 times 3 for 3 specific instances? This is really an ambiguously written law that threw the firearms community through a loop.
Intentionally so. Some hunting group went in there and said, let's clean it up a little. And they made a couple minor changes, none of which helped. In fact, some of it hurt because we had to relitigate the case now because the state argued, oh, we fixed everything. Well, they didn't. But yeah, this is the chilling effect. This is the goal of the state and the politicians and bureaucrats who hate private gun ownership. They want to scare you away from buying a gun or marketing a gun or selling a gun because they want you to think that you might do something wrong and get prosecuted. And in this case, they also want to wipe out exposure of the younger generation to firearms and the social utility of firearms and the discipline involved in the shooting sports and all the fun that going to the range can be. They don't want the minors, the next generation, to know about that. That's why they don't want to have gun shows. They don't want to have any kind of cultural events where the next generation could be exposed to the positive aspects of firearms ownership, and because they want to murder the gun culture. They want to reduce us as a political force and make gun ownership largely ignored and unacceptable. And this is one of the ways they do it.
Yeah, which makes the injunction on, a law like this all the more important. Obviously we know that when we go to argue, and we think that about everything that we challenge, but these ones specifically, the fact that a law can essentially bring an entire demographic to a standstill is really scary. So the injunction is extremely important in this one. But being at the Ninth Circuit, we'll look forward to seeing how we can make that permanent going forward. And we've got one more lawsuit here, Chuck, that I wanted to talk about. It's something that we talked about really recently, just filed with the Supreme Court. We'll see if they take it up, but that's B&L Productions v. Newsom, specifically pertaining to firearms sales at state-owned property. Can you give us the rundown on this one and the progression we saw this year?
This is B&L, which is the owner of Crossroads of the West Gun Shows, and I want to make sure I give them a hat tip. And by the way, I also should say, in both the Rhode and the Duncan case, NRA is a partner in those cases and has been working with us since they started to move them along. But the rest of these are basically CRPA's babies, and we've been fundraising to finance these. We get great discounted rates from our lawyers to handle these cases, but it's still an expensive proposition. And so I really appreciate the folks who are giving 20, 30, 50, or whatever they can afford. Some big donors out there, I really need to buy you guys dinner, have really made it possible for us to do all these lawsuits and to be ready to do more as more laws are passed. But banning gun shows is part of the war on the gun culture, because they don't want us to get together and talk about firearms ownership and have fun. At the Crossroads Gun Show in Del Mar, I've been there multiple times. They haven't been in other parts of the state. They're still having them in some parts of the state because there were contracts in place. But ultimately, the court said, well, you can have the guns at the gun show and you can offer them for sale, but you can't accept someone. No one can accept the offer and actually buy the gun, even though you can't walk off the property with a firearm. It still has to go through the 10-day waiting period. So it just turns free speech, and particularly commercials free speech, on its head. It says we can offer it, but you can't close the deal. You can't accept somebody who says, I want to buy it. You can't allow them to. So we're hopeful there were several cases here that the CRPA litigated along with Crossroads, and we're very hopeful that the Supreme Court will see, because the Supreme Court isn't particularly fond of the limitations. You have less free speech rights for commercial speech when you're selling something than you do for political speech. And trying to draw those distinctions between what is this speech, is it commercial or political, or some other type, has caused the court a lot of problems. And the Supreme Court, and particularly Justice Thomas, has shown an inclination to just dump this whole distinction between commercial and political speech and talk about for the First Amendment in terms of speech. So we think it has a lot of attractive aspects to it, not to mention the Second Amendment component. So I think that we're hopeful that the Supreme Court will take this case.
Well, we've certainly seen a lot of progression throughout the year on the majority of these lawsuits, and it's not like it's one or two lawsuits. There is a big handful here that we're going to continue litigating throughout 2025. Chuck, I do appreciate you coming on, giving us the insight and being able to look back throughout the year. Do you have any final thoughts just overall on Second Amendment litigation here in California for the year?
Well, yeah, it's not over. We're going to litigate these cases. We will win most, if not all of them. And when we do, the game will change in California, but the politicians will not give up. They will continue to try and do whatever little shenanigans that they can come up with, whatever harassment they can come up with. I think I saw something where they're going to try and say you can only sell guns in particular colors. I mean, it's a form of harassment to try and stifle the exercise of our fundamental right to keep and bear arms. And they're not going to just roll over because the Supreme Court slaps them down again, and it eventually certainly will. And let me just say, thank God that Donald Trump is now the president, because our likelihood of winning would have gone down significantly had he not been in there. The Ninth Circuit, the composition of the Ninth Circuit changed dramatically under his last administration, which is why we have some judges up there calling out their more progressive liberal colleagues for the games they're playing. But in the meantime, whatever you can do, this is a historic time. Legally speaking, this is a historic evolution of the law, and it's going to be written about for centuries about how things evolved in the United States. And securing this right for ourselves and our children it's the tip of the spear on freedom and for the soul of America. So if you donate a little money and join the CRPA, you become a part of that history. And, you can be proud of the fact that you're fighting for joining with the CRPA team and the other members. We're working with other groups too. All the other groups have all kind of gotten together now because the NRA was having so many problems, and are working together more than they ever did before. To secure our freedoms and our Second Amendment rights, but it does take work, it takes time, and despite the great rates that we get, it still takes money. So whatever you can do to help us out in that respect is greatly appreciated by me and all the people that work for the CRPA and that are members of the CRPA and are all interested in being able to keep our Second Amendment rights.
Well, I will certainly second that from this end. Chuck, I do, again, appreciate you taking the time. I know you're a busy guy. That's self-evident here with all the litigation, but I appreciate the knowledge and the wisdom here, and I appreciate you coming on.
Looking under 2025, which, by the way, is the 150th anniversary of the California Rifle and Pistol Association. We're actually the oldest civil rights group, I think, in the country. I think we're older than the NRA. But this year, 2025, is our 150th anniversary, so they've got some great merchandise in the store, and they'll be they're making it available at all the places where we are the events, and so join us in celebrating 150 years of fighting for freedom.
Absolutely, yeah. I think we're a couple years younger than the NRA, but couldn't have been more perfect the way that it lined up, because we get to celebrate 150 years while the country celebrates 250 years. So, or at least since the shot heard around the world. So, definitely looking forward to celebrating that throughout the year. Chuck, again, thanks for coming on.
All right, my pleasure, guys.
Absolutely. And guys, if you like content like this, if you like learning about these lawsuits, and if you want to directly contribute to them in the future, please be sure to like, share, and subscribe to these videos. It really helps us get that information out there for as many people as possible to be educated, so that we can use that to fight for the culture moving forward. Thanks again, guys, and we'll see you on the next one.